Good morning.
Morning. Just a second.
Of course.
All right. Good morning, everyone. This is Judge McBurney, and I am here hopefully hopefully we are together for 2020 CV 332509, which is an appeal brought by Mr. Beard, the former CFO of the city of Atlanta, an appeal from an ethics board decision that was adverse to him to the tune of many thousands of dollars. So it's Beard versus City of Atlanta is how the case is styled. Why don't we figure out who all is on the call? Who do we have for Mr. Beard?
Judge, good morning, and good news, you are in the right place. So we have Brittany Cambry and Scott Grubman on behalf of Mr. Beard, and it will be Ms. Cambry who will be presenting this morning.
Okay. Well, good morning to both of you. And who do we have on behalf of the city?
Good morning, Your Honor. Karima Lewis on behalf of the City of Atlanta. We have been dismissed from this action. I am here merely in support of Mr. Endermark and just to observe.
Okay. And Mr. Endermark, you represent?
All right, I represent what is now currently termed the City of Atlanta Governing Board of the Office of the Inspector General. At the time of the incidents involved in this case, they were called the City of Atlanta Board of Ethics, and then the name changed to the City of Atlanta Board of Ethics and Independent Compliance. So I will simply refer to my client as the board, if that is okay with all parties present.
I'd appreciate that. Otherwise, we'll be here until next Tuesday if you have to repeat that name each time.
Thank you, Judge.
We also have Ms. Niles on the call. She's my staff attorney. She will be listening in and taking notes so she can help me work through the issues that are presented so I can get a ruling out soon embugh. I'm ready to go. Let me tell you all what I understand the posture to be, and then Ms. Cambry, I'll let you take over from there, and then we'll hear from Mr. Endermark. Ms. Lewis, you're free to chime in whenever, but it sounds like you ought not to have much to say since everyone's agreed that the dispute is Beard versus board, and that's how we'll keep it. So as I understand it from looking at a bunch of the pleadings and the record from below is that Mr. Beard was the CFO of the City of Atlanta. After he left the employment of the city, the board began an investigation into alleged misuse of the city credit card for things like fancier airfare than is authorized, fancier hotels, go-go in-flight internet, lots of different things that were very well documented in the sense that please explain what this flight was about and this flight and staying in this hotel, coupled with an allegation that some of the travel or entertainment in which Mr. Beard engaged was actually for a different job he had. He was the member of some board or municipal something association and got paid for that, and yet used a city credit card to bill the citizens of Atlanta for travel associated with work he was doing not for the city. Those are all the allegations. In some respects, the allegations ended up being admitted by default. I don't mean to suggest Mr. Grubman ever admitted anything on behalf of his client. He said, we deny it and we don't have a way to fight these charges because, and this is what I understand the defense to have been, number one, and we'll spend a fair amount of time on this, no jurisdiction. The Board of Ethics is empowered to investigate the ethical lapses of employees, not former employees. And Mr. Beard, I think by everyone's admission, falls into that latter category. He was not working for the city when the investigation was going on. That was objection one. Objection two was that sort of two pieces, but they all relate to Mr. Beard not having the information needed to defend himself or to respond, because a lot of what the Board of Ethics was asking for was, you justify this, Mr. Beard. You took this trip. We can't find any documentation justifying you flying in first class, or you bringing these 5 other people with you, or you spending this much at this fancy restaurant. So please justify it. And one of the responses was, well, I don't work for the city anymore. All that paperwork ought to be with the city. So you ought to have it already. And the board responded back saying, well, we've looked and we don't have anything justifying it, which is why we're investigating you. Okay, how about we look on my computer? And then things get particularly messy for the board. Well, the city repurposed your computer and whatever was on it isn't there anymore. And we can talk about spoliation and whatnot, but I will tell everyone going into this, that strikes me as an issue, that the board wants to go after Mr. Beard, and a repository for some things that might justify his actions would have been his city issued computer. And instead of preserving its contents, which it didn't have to do by keeping the computer out of commission, they simply could have imaged the hard drive. They repurposed the computer, and as far as I can tell from reviewing the record, all is lost in connection with that. So I think that's sort of procedurally and factually where we are. And I share that just so you don't have to repeat things that I have managed to absorb, but I may have absorbed things incorrectly or only partially. So feel free to fill in around the edges or right in the middle if I miss something. And with that, Ms. Cambray, why don't you let me know why it is you think that the decision of the board ought to be undone?
Yes, good morning, Your Honor. And as you outlined the procedural history, I'll just go ahead and jump right into the arguments. The first being that the board erred when it found that it had jurisdiction. Based on how the Atlanta Municipal Code defines an official or employee, the stated purpose of the code, etc., the board's ability to investigate, sanction, and in particular recoup gratuities is limited to current officials and employees. In particular, section 2801 of the code defines an official or an employee as any person elected or appointed or employed or retained by the city. It goes on to say that this definition includes retired employees or former city employees during the period of time in which they are later employed or retained by the city. That second sentence wouldn't be necessary if the definition of official or employee contemplated former employees. The fact that it goes on to say the definition includes former employees that are later retained or employed by the city operates to exclude from the definition former employees who are not later retained or employed by the city.
So let me ask you a little bit about that. I think more of the heavy lifting will come from Mr. Indermark, because I appreciate your explanation of the provision. I'm actually looking at it on the screen. Mr. Indermark provided the relevant code sections, and it's on page 3 of what he shared with us. Assume for a minute that I agree with you, Ms. Cambray, as to the meaning of the definition of official or employee, which would be Mr. Beard. That would mean that the Board of Ethics has no ability, and thus the city, no ability through the Board of Ethics, the board, to try to go after and recoup from a former employee the fruits of his or her malfeasance. And that seems like that wouldn't have been the purpose of the city council when it enacted the Board of Ethics and all of its supporting legislation. So what am I missing and scratching my head to say, well, that means they have to act real quickly, because if the Board of Ethics says, hey, we're interested in you, McBurney, all I have to do is quit, and then they can't do anything to me anymore. How does that make sense?
Well, although the board wouldn't have the authority to investigate or oppose administrative sanctions pursuant to this particular municipal code, the board would have other remedies to go after wrongdoing, such as embezzlement, fraud. You could initiate a civil action against the person. You could refer the matter to local law enforcement for prosecution. So it's not as if that employee would get off scot-free. There are just other avenues by which the board in the city would have to pursue recovery against that employee.
Do you know, I don't know what your area of practice is, but is it fairly typical from your experience that boards of ethics jurisdiction is limited to sorting things out with an employee while he or she is still an employee? Or if I end up agreeing with your interpretation, which is a fair interpretation of the meaning of official or employee as it is defined in 2-801, would that put Atlanta as a bizarre outlier, that Miami, or just let's keep it local, Alpharetta or Macon, that they are empowered to investigate ex-employees and impose sanctions on ex-employees?
Admittedly, I'm not familiar with how other cities or municipalities have their code of ethics, but particular to the city of Atlanta, the stated purpose of the ethics code as provided in section 802 is to discipline employees or officials, which the city council, the municipal code itself defines, we would submit, to exclude former employees or officials unless they are later retained by the city.
Okay. All right, so I stopped you with a question. You should keep going.
So another sort of reason why we think our interpretation is supported by the code is that all of these provisions upon which the board relied to investigate and fine Mr. Board are located in Chapter 7, which is titled Officers, Employees. And then the code later defines that particular term in the way that we have discussed. And although section titles are certainly not dispositive of the meaning of an ordinance, they may always be considered as aids to its construction, as the Supreme Court in Bentley versus State Board of Medical Examiners of Georgia has stated. And we think that this interpretation is reasonable. The fact that the municipal code doesn't provide any statute of limitations means interpretation, the board's authority is limitless temporally. Our interpretation bakes into the board's authority a temporal limitation that they can only investigate or fine people during the pendency of their employment. And after that, their jurisdiction, at least with respect to administrative sanctions under this code section, is limited. And the lack of any temporal limitation on the board's authority is problematic. It raises all kinds of due process concerns, evidence disappears, memories fade, employees no longer have access to the documents that they maintained as city employees. And the very purpose of a statute of limitation is to prevent decisions from being made on deteriorated evidence or evidence that no longer exists. And as you've mentioned, that is not a hypothetical in this case. Mr. Beard sought recovery of his city documents located only on city computers. And after he left the employment of the city, they repurposed his computers and those documents cannot be found. They're not located. Whether that was advertent or inadvertent is a question for somebody else to decide. But what it does not mean is that Mr. Beard should be penalized for not being able to present the evidence that could potentially exonerate him of these allegations. And this is particularly true in proceedings like this one, where there isn't a right of discovery baked into the process. Here, the board said, we have some evidence against you. The onus is on you to prove these allegations aren't true. And both the code itself provides that the hearing officer or the board must make decisions on a preponderance of the evidence. But here, by forcing Mr. Beard to not have the evidence available to him or to make decisions based on the record where there is no exonerating evidence, has improperly shifted the burden to Mr. Beard to prove his innocence instead of the board proving their position by a preponderance of evidence. And, I think we've attached his exhibits. I'm happy to walk through them if you want, but we have the correspondence where Mr. Grubman submitted an Open Record Act request and the city has responded. I don't think I need to show them to you.
I looked at that last night as I was trying to understand a little bit more about what happened leading up to where we are today, and saw that there wasn't a whole lot provided. Some of it was deemed to be exempt. Some of it they couldn't find. And then we had this hard drive disclosure.
Judge, I hate to interrupt.
Repurposing.
I hate to interrupt. I'd like to impose an objection to those documents as they are not part of the underlying record.
Okay.
The documents were never made privy to the board during the hearing process. They're not in the record that you're reviewing to determine whether the board erred or not.
Well, fair point. And let's make sure we're clear as we discuss this, what I was referring to and maybe what Ms. Cambray was referring to. And I will be clear that I understand that I am limited in my review of this challenge to the facts and the record as it existed before the board at the time. I don't know what the status is, and I guess Mr. Endermark, you may focus on this. If we just take the hard drive as an example, I don't know if it was before the board that the city had repurposed the computer, Mr. Beard's computer. I don't know that I am forbidden from considering that fact if one of the grounds for reversal that Mr. Beard's attorneys are raising is a due process violation. That may not be in the record, but shame on the Board of Ethics for not knowing that the computer got repurposed. If part of their conclusions, as I've read them, were, well, Beard utterly failed to respond with anything. But I may be mixing and matching certain things, the Open Records Act's requests and how it might have been brought to the board's attention. I thought there were letters that Mr. Grubman wrote to the board or counsel for the board that highlighted some of these things, such as my client's computer's gone. What are you specifically referring to, Mr. Endermark, so I can rule on your objection?
Sure. No, you're correct about that. There was a letter from Mr. Grubman to the board that made a general allegation that Mr. Beard's computer had been repurposed. But
Okay.
What I'm referring to specifically are the plaintiff's proposed exhibits. I can tell you exactly what number.
Well, I've got the list in front of me. So there's
Regarding
1 through 16.
Yeah, between the correspondence between Mr. Grubman's firm and the city and or the city attorney's office that provides more detail about what the open records requests were and what was. None of those correspondence or details were provided to the Board of Ethics. The only thing the board knew was what was in Mr. Grubman's letter to them. And consequently, those exhibits are not part of the underlying record that the board relied on.
So I'm looking at the list of 16 exhibits. Which of those, I looked at a number of those letters last night. I'll rely not on the ones that I shouldn't rely on, and I'll certainly give Ms. Cambray a chance to respond in a minute, but which specifically are you concerned about?
I contend that they are plaintiff's exhibit number 9, plaintiff's exhibit number 11, And plaintiff's exhibit, I guess that's number, let me double check if it's number 13. Yes, number 13.
Okay. So, Ms. Cambre, what's your response to Mr. Indermark's concern about me considering and you frankly discussing the open records requests and really the substance of your exhibits 9, 11, and 13?
The issues that were raised by the Open Records Act requests were expressly provided to the board in correspondence to Mr. Grubman, which I believe is exhibit 14. And therein, Mr. Grubman explains to the board that in response to an Open Records Act request, we were told that the documents were the computer was repurposed and the documents could no longer be found. And he raised in that letter an issue of spoliation. So regardless of whether exhibits 9, 11, and 13 are admitted before the court, the issues discussed therein are in other portions of the record that was specifically considered by the board. And in particular, the final opinion references this issue and says, we don't know anything about this issue, but nonetheless, we're going to proceed anyways. And that's, I believe, exhibit 16, page 4, paragraph 25. So the issue has been decided by the board and is properly before you. Whether those 3 letters make it into the record is somewhat immaterial.
Okay. Well, Mr. Indermark, I'm going to sustain your objection. Let's not talk about the open records requests anymore. I think, Ms. Cambre, to your point, it's not going to move the needle much. I just looked at Mr. Grubman's letter, not to the city, but to the board, that he then asked to be made part of the public record, wherein on page 2, he highlights the spoliation concern. And I'm now looking at paragraph I'm looking at the final report, and 1119. Which paragraph did you say, Ms. Cambre?
It's 24 and 25.
Yes, there it is. Okay, so that was before the board. They did what they did with it, and I think that's what we need to limit our focus on. Okay, so I think we're back on track. Thank you, Mr. Indermark, for flagging that. Sometimes it's hard. I get what I get from the lawyers, and I say, great, this is what we should be talking about. But we are statutorily limited to what happened below with the board, and not things that are connected, but are effectively on the sidelines. That would have been interactions with the city. As Ms. Lewis has let us know, the city is no longer a party to this. So you were talking about, Ms. Cambre, some more due process concerns, the burden shifting, and the spoliation concern. That's sort of where we bled into the, I may have brought it up, the open records requests.
Yeah, so just to sort of close the loop on what I was talking about with the statute of limitations issue, is that only petitioner's interpretation provides for some sort of statute of limitations on the board's authority. And if in the civil context, and even more serious crimes, ranging from personal injury to assault and battery, have statute of limitations connected to them, it's inconceivable why the board's jurisdiction would be unlimited by a statute of limitations. And but
is there any case law you have that says that municipal or county boards of X, whatever it might be, anything with investigative authority, has a statute of limitations? I'm familiar with the statutes of limitations, but they would limit you bringing a lawsuit or the DA's office seeking an indictment. I'm not aware of those provisions controlling administrative agencies. Now, the due process concerns, and that's certainly something to look at. And so if you're arguing, look, by analogy, Judge, that ought to apply here, we can work through that. I don't know, though, that this investigation happened so far in time after Mr. Beard's departure that it would run afoul of due process statute of limitation concerns. If we were having this conversation in 2030 about what Mr. Beard allegedly did with his credit card in 2016, that would resonate more. But it sounds like you're making a policy argument for a set of facts that doesn't really apply here.
Yes, we're not saying that any statute of limitation has been violated in this instance. We're simply saying that our interpretation of the definition of official or employee bakes into the code a statute of limitations, and that's a good thing.
Okay.
And in the hearings, the ethics officer took the position that, you know, our interpretation was against public policy, and you know, as you said, questioned would there be any inability to go after that wrongdoing, and there are other provisions that allow for remedies. But even if the board is correct that it has the authority to investigate any alleged violation of the ethics code, what the board's argument doesn't address is its remedy for an investigation and whether it can penalize somebody. And there's a difference in how the code is written, particularly with respect to this gratuities argument. 807E of the code limits the possible remedies for gratuities to current employees or officials.
Can you say that number again? You froze up, or Zoom froze you up. 807. You still there?
Did you hear me? It was E. I'm sorry.
Okay, 807E. All right, that's on page 10 of the code excerpt that Mr. Indermark provided. Okay.
And so the board takes the position that it can investigate wrongdoing as long as the person being investigated was a current employee at the time of the alleged wrongdoing. While that may be an ordinances, the violations and appeals provision, section 807, limits the board's impose the recoupment of gratuities because it incorporates into that provision. I'm sorry, I'm getting a message that my internet is unstable.
Yeah, Brittany, you might want to just start that.
It's a little choppy. Why don't you make that argument one more time about how 2-807 precludes the board from doing what it was trying to do?
Yes, so 807E is the provision that allows the board to recoup gratuities transferred or received from an employee or an official. And because that provision, it incorporates explicitly the term official or employee, if you agree with our interpretation that our official employee is solely current employees only, then that would mean that the ability to recoup gratuities is limited to current officials and employees. And there may be other provisions such as the administrative sanctions provision that doesn't explicitly incorporate the term official or employee that would allow the board to impose administrative sanctions on Mr. Beard. So we submit that the board doesn't have any authority over former employees, but to the extent you're inclined to agree with their reading of that, it's limited to administrative sanctions, not the gratuities piece.
And tell me one more, why does the gratuity piece not apply? Because Mr. Beard was not an employee or official at the time of the investigation?
Yes, because section E explicitly incorporates the term official or employee, which as explained is defined earlier in the code section as current officials or employees.
Okay. All right.
Okay. So unless you have any further questions about the jurisdiction piece, I'll move on to the second issue.
Mr. Indermark, I'm fine hearing from Ms. Cambre about both pieces, the jurisdictional piece and due process concerns, and then hearing from you. Are you all right with that, or are you real anxious to talk about the jurisdiction piece now?
I was muted. I'm fine with that, Judge.
Okay, then Ms. Cambre, why don't you keep going?
Okay, so the second issue is that the board erred in failing to consider exonerating evidence. There's some due process concerns by the fact that Mr. Beard was unable to get access to documents in response to these alleged violations. And OCGA 5412B requires that the board be overruled if it was not supported by substantial evidence. And here, there is no substantial evidence to justify the board's ruling here for two reasons.
Now,
First,
before we go on, just so we're all clear, we know substantial evidence means any evidence.
yes, Your Honor.
So, okay, all right. So we've got these allegations and we've got receipts. We've got some pretty fancy restaurant bills and whatnot. But you're going to tell me that there was no evidence, or you're going to tell me, yes, there may have been some evidence, but there were due process issues?
Yes, Your Honor. And from a initial perspective, this evidence that these transactions occurred is not evidence of a violation of the ethics code. It's simply evidence that these transactions occurred.
Okay.
And what the board or the ethics officer was asking in this investigation was provide a business justification for these expenses. And Mr. Beard was unable to do so because the very documents that could explain the business justifications for this stuff resides on a computer that has since been repurposed. So Mr. Beard was unable to do so. And despite that objection that was raised for the board's consideration, they nonetheless proceeded to impose the sanctions that they did here. And
let me pause you for a second, because I don't want to leave hanging this. It's not your main argument on this due process side, but I'm hearing you say, another thing, Judge, is that one could argue that there was not substantial evidence to support the board's finding. And setting aside the potential burden shifting aspect of it, my understanding is that a number of the transactions, if not justified, were violations. And so the board said, here are these things, they look problematic. What do you have to say, Mr. Beard? And Mr. Beard's answer, as they viewed it, was, I have nothing to say. I declined to say anything. And it was more than that. They were a little dismissive of the due process issues, but in the end, their conclusion was, you said nothing. So you did not justify them. And so they are violations. You traveled in a manner that was inconsistent with city policies unless justified. You didn't justify them. That lack of justification means there is substantial evidence. So you need to, if you are one of your arguments you want me to consider is that in fact there was not substantial evidence, you need to talk some more about that, because I don't follow your logic. If your point is instead, it's kind of an unfair setup, because he's got to effectively prove his innocence, your phrase, not mine. And then they don't give him the tools with which he could prove it. How could that be fair? I follow that, and Mr. Indermark's going to need to address that. Are you also arguing, and by the way, Judge, there was not enough evidence?
Yes, for two reasons. First is that the evidence submitted simply shows transactions. And in the hearing itself, the ethics officer doesn't call any witnesses, doesn't provide any testimony to say one way or the other whether those are justified. He simply says, and he posits in the hearing, it leaves us wondering why there is no documentation. That simply does not meet the board's or the ethics officer's burden of proof to prove by a preponderance of the evidence that there was a violation of the ethics code. And furthermore, all of the evidence submitted by the ethics officer is impermissible hearsay. Chairwoman Walsh opens the proceeding by saying this proceeding is governed by Georgia's rules of ethics. And all the proceeding is Mr. Santiago saying, here's a credit card or here's documents showing a transaction. He got them from the city of Atlanta. They were never authenticated. There's never anybody to testify that these are admissible business records exempt from the hearsay rule. And no one at the hearing was able to authenticate, lay the foundation, or otherwise admit properly the evidence to the board. So the documents themselves don't prove that there was a violation, but there actually isn't any admissible evidence for the board to consider because all of the documents are impermissible hearsay.
Judge, can I interject one objection to that?
Sure.
This hearsay argument, this argument that there was no substantial evidence was not in their enumerated errors in their petition for writ of certiorari. So it's not properly before you.
Well, it's one reason why they explain why I'm a little surprised by it, not because I necessarily disagree with it, but I thought we had the jurisdiction argument and the due process argument. So, Ms. Cambray, where can you point me and Mr. Indermark to where in your petition you allege that an additional basis for reversing the board's decision would be lack of evidence or lack of admissible evidence? Because one argument you're making is they didn't prove anything, and two, the only things that they did admit you can't consider, or they shouldn't have considered, even though no one objected to it, because it was all impermissible hearsay.
We don't use the terms hearsay in the petition, but we would argue it falls under subsection M of our petition, where we say that the board's decision failed to consider, exonerating evidence and proper evidence. And, the court has the authority to decide whether or not there were legal errors made by the board, and if necessary, petitions for certiorari are amendable at any stage as to form or substance. So, if it's a matter of a technicality, we would seek to, amend the petition to address this issue.
Okay, I'll let Mr. Indermark address that when he's up. What I heard you say on this hearsay issue, Ms. Cambray, is that at the start of the hearing, the chairperson said this proceeding is governed by the rules of the Board of Ethics. Did you mean the rules of evidence, or she said the Board of Ethics, and where in those rules does it say that hearsay is not allowed? I don't know that this is a proceeding where hearsay is forbidden.
You're right. I misspoke, Your Honor. I meant to say that the Chairwoman Walsh opened the enforcement hearing proceeding and had some introductory remarks and noted that Georgia's rules of evidence apply, and cites the code section of the Georgia evidence. We would argue that that means that the board was bound by hearsay rules when making its final decision here.
Okay, so if I have a trial, bench trial, and a bunch of hearsay comes in, but the other side doesn't object, I can consider that evidence. I'm not forbidden from doing that. Was that not a risk that your client took by declining to attend the hearing?
Well, and all of this presupposes there's jurisdiction to exist to
Correct.
do this, but we would argue that there was no effort to overcome hearsay, and we couldn't have objected to preserve the issue for appeal because we were preserving our objection to jurisdiction. So this will segue into an argument we're going to make, but if you are inclined to find that the board has jurisdiction here, we would argue that a remand is appropriate to allow Mr. Beard the opportunity to appear and present legal and documentary evidentiary defenses that may exist. And the reason why remand would be appropriate here, and we didn't waive that right, is in a normal proceeding, you have the ability to immediately appeal jurisdictional issues before you go down the road of presenting evidence, and that right just doesn't exist here. So we would argue, as a matter of fairness, in order to object and preserve these issues and provide Mr. Beard with due process, which the municipal code specifically says is afforded to people who are being investigated and brought before the board on charges, a remand and an actual opportunity to participate in the proceeding would be required.
Okay.
And I think we've covered this, but just a few couple of points here is that, to go back on this issue, that the evidence presented to the board just shows that transactions were made. The hearing officer in that proceeding merely asserted that the lack of documentation meant that there was no business purpose for that charge, and that's just simply not supported by any of the corroborating evidence. And in fact, the board appears to use the fact that Mr. Beard did not appear as an aggregating factor in finding that he is liable or has violated the ethics code, and does so, says that his failure to appear somehow in inference that there is no justifiable purpose. But the board never addresses that inference in the context of why Mr. Beard chose not to appear. He chose not to appear to preserve his right or his objection to jurisdiction, not because he didn't have the evidence or the testimony to defend charges. So the board sort of makes very light or gives very little weight to Mr. Beard has a jurisdictional defense, and that's why he has not appeared. In addition to giving very little weight to the fact that the evidence that would exonerate him was destroyed by the city and the person who has control over all of that. And they just do not give any weight to that fact, and instead proceed to find him to have violated it. And that just is not the preponderance of the evidence standard. It violates, all notions of fundamental fairness, that, you said nothing and therefore you're guilty, but ignoring the reasons why he said nothing. And that's just not taken into account in the board's final opinion. And therefore it lacks substantial evidence to support, the approximately $100,000 assessed against Mr. Beard.
Okay.
And unless you have, any further questions, I will turn it over to Mr. Endermark for now.
Okay, we'll do that. You should know that when he's done, I'll let you have final word as the petitioner, in case there's something you want to respond to that Mr. Endermark shares with us. So, Mr. Endermark, you're up. Let me know where you want to start.
All right, Judge, thank you. I'm going to start with the statutory analysis. And what I think is the real issue in this case, and that is in bringing this writ of certiorari action where they allege that the board has no jurisdiction over Mr. Beard, what they're asking this court to do is, in our opinion, to misinterpret the language of the city code so as to give employees, not the ethics board, power to stop ethics investigations into what they did while employed by the city. And why their interpretation of the ethics code is incorrect is as follows. Again, if I'll direct the court to the copy of the code I provided, what they have essentially done here is cherry picked out one provision in a definitional section that defines who is an official or employee. I think the beginning of the analysis needs to go to section 2802, which is the purpose of the ethics code. And that says it is the purpose of this division to promote the objective of protecting the integrity of the government of the city by prohibiting any official or employee from engaging in any business, employment, or transactions that are essentially unethical. I'm paraphrasing that last section.
Sure.
Now, so that raises one question. All right, that governs what actions are prohibited. It prohibits unethical actions by officials or employees. Okay. The definitional section is there to let people know whose actions are prohibited. It is not a limitation on when a matter can be investigated. It's simply saying if you are a public official or employee, then your actions can be regulated by the ethics board. And then again, and I'm sure at some point someone said, well, I'm a retired employee. Does that still apply to me? And the answer is no, because you have to be working for the city at the time of the violation for the ethics board or the ethics code to apply to you. So they describe what actions are covered, not when they can be investigated. There's no language in here or anywhere in the code, for that matter, that says the ethics code does not apply to former employees and officials, nor does it say anywhere that they lack jurisdiction to investigate former employees or officials. And in fact, in section 8, let me make sure I get this right. 804 subparagraph K, it says the Board of Ethics shall have the authority to investigate any alleged violation of the Code of Ethics. So if there was a violation of the Code of Ethics by an employee who was working for the city at the time the violation occurred, then they can investigate it. Obviously, if you're a ex-employee and do something, they're not going to go after you for what you did as an ex-employee, because the code, with limited exceptions, would not apply to you. But if you do something while an official or employee of the city, then that can be investigated. And there is simply no language anywhere to the contrary. In fact, if that wasn't sufficient to make clear that the board has jurisdiction to investigate actions committed by people working for the city, then I turn your attention to section 28-10 and 28-14, which specifically regulate post-employment behavior. Section 2810A states that no person who has served as an official or employee shall, for a period of 1 year after separation from such service or employment, appear before any agency or receive compensation for any services rendered on behalf of any person. So again, the interpretation that official or employee excludes people who no longer work for the city is contradicted by that section. And it's also contradicted by section 214, and I'll find subsection E, where it says every official and employee is required to file an annual disclosure statement, and that includes the year following that in which the official or employee leaves such position. So when you read that position, clearly official or employee is not limited to current employees. Otherwise, that whole provision would be meaningless. So from the statutory side of things, it's our argument that there is no ambiguity in the statute here. The statute regulates behavior by persons while they are employed by the city, and that's defined to mean officials or employees of the city, and that's what defines whose actions are covered by the ethics code. It also says that the board can investigate any alleged violation caused by that behavior, and there is no limit on when someone may be investigated. Now, I know that this statute of limitations argument was brought up. The ethics board generally as a practice follows a 2-year statute of limitations. So the notion that this could be brought 30 years from now is simply inaccurate under the current practices of the ethics board. Now, I know there's nothing in the ethics code itself which sets forth a statute of limitations, but that is the practice of the ethics office. But in any event, to say that this violates the statute of limitations, there would have to be one written down somewhere. But in any event, the ethics code nowhere states that the ethics board cannot investigate former employees for what they did while they were employed by the city. So again, our position is these provisions are clear. They describe what actions are covered, not when violations can be investigated. Now, to the public policy arguments.
Let's go back for a minute before you go to public policy to the definition of official or employee. If official or employee didn't mean you while you're working here, if it meant, I guess I don't understand the second sentence. I understand what the second sentence says, but if official or employee means, doesn't matter if you're still here or not, anytime you worked here, once an employee, always an employee. So if you worked here in the year 2005, you're an employee for the purposes of everything in this whole code. Then why do you need the second sentence?
Well, I think, all right, let me back up again, Judge, and try and see if I can make this any more clear. So 2802 says it prohibits officials and employees from engaging in unethical behavior.
Yep.
That's the purpose. So then you have to go to the definitional section to see who is covered by that. All right, who is an official or employee that is prohibited from acting unethically? So obviously, or perhaps not obviously, the first thing they had to do was say, okay, this covers every person appointed, elected, or employed by the city. That is an official or an employee. Now, it also covers retired employees or former city employees to the extent that they are working for the city at the time of the alleged unethical activity. That is our contention of what that definitional section is intended to clarify. You know, there are lots of rules and regulations about retired employees. Are they an employee of the city or not? If you're a retired employee, you're not deemed to be an employee or official for the ethics code. So it's not going to regulate, you know, whether you want to go to Walmart and buy a cooler, right? Because that's not something you're doing as an employee or official of the city. But if you are still working for the city as a retired person,
so what does that mean? I mean,
that means I think in some ways it's just sort of an abundance of caution.
But you're not retired if you're working for the city. I mean, the hang up, the problem for the board and the city, and I think the only toehold that is very creative argument by Mr. Beard, and it's somewhat persuasive because of that second sentence. You're either working for the city or you aren't. You may have worked there for a while, then you retire. You're not retired anymore if you're working for the city. So why have that second sentence if all of these provisions were meant to apply to anyone who at some point in time was an employee? You don't need that second sentence unless official or employee means, no, wait a minute. This only applies to folks who right now are on the payroll of the city of Atlanta.
I don't have the Pension Act in front of me, Judge. I'm very familiar with other city and counties' pension acts. And I can tell you, like for DeKalb County, for example, there are regulations that specifically say as a retired employee, you can work on a limited basis without losing your retirement or your pension benefits. I think it's directed at something like that. And as far as former employee, later retained or employed by a city or an agency, they may be employed as a consultant. They may be employed in an outside fashion. I'm not sure, but I think the intention is clear that this covers anyone who is currently providing any services to the city. So even if you're receiving your pension benefits and would otherwise be considered retired, if you're allowed to work on a limited basis, you can't then come and say, oh, the Pension Act doesn't apply to me because I'm retired. Now,
but you basically just made Mr. Beard's argument. This applies to anyone currently on the payroll of the city. Of course, Mr. Beard's not on the payroll of the city. When he got that letter from the Board of Ethics, he was not on the payroll of the city. So
the distinction there, Judge, is they're not investigating him for anything he did once he left the city.
Mm-hmm.
They're investigating him for what he did while he was at the city, and there's no dispute about that. So there's no dispute that everything he's being investigated about occurred while he was an employee or official of the city. And they're trying to take a definitional section and horn it into an argument that the entire ethics code does not apply to people once they quit the city or resign or fired or lose their term in office. If there is a provision in here that said the ethics board can investigate any current official or employee of the city, that would be a different matter, but it doesn't say that. The language of the code says any alleged violation.
Yeah, so let's turn to that then. So that is the 804. It's interesting because it says violation and not employee.
Right.
Go to K. Is there any other language you found that talks about the Board of Ethics jurisdiction and scope vis-a-vis the actual actors as opposed to the actions? Because K talks about an action. We can look at it a violation of the Code of Ethics. And this is taking us way far afield. I don't want us to go any further than, but it could be a violation of the Code of Ethics if I, as a vendor or a would-be vendor, paid a bribe. Now, the person who took the bribe or solicited it as a City of Atlanta employee certainly would be subject to investigation, in particular if he or she was still on the payroll. But it says violation as opposed to person. Is there anything that you were able to find that says employees are subject to investigation of the Board of Ethics that would?
Well, I think the board investigates unethical actions. They don't go and say, employee X, we're going to investigate you because you're an unethical person.
Okay.
They say, we're going to investigate your actions to determine whether those actions were unethical.
Okay. So let's say.
So, but Mr. Beard is arguing for a hard line here. He says that the definitional section of the code, section 2-801, says that they have no jurisdiction over former employees or officials, period. And sections 2, let me find that, 2-810 and 2-814 specifically state that they have authority to govern post-employment activity in certain circumstances. So that definitional section, if it meant what Mr. Beard says it means, would invalidate 2-810 and 2-814 as well. Not to mention completely gutting the entire purpose of the ethics code, which I'll get into as a public policy argument.
Okay.
I hope that was responsive to your question, Judge. I'm certainly happy to answer any more questions you might have.
No, it was helpful. Thank you.
All right. So that's our statutory argument. Our position is it is clear that the ethics code does not mean what Mr. Beard argues that it means by the actual language of the code itself. Since Mr. Beard raised public policy arguments, we will do likewise. So obviously, Mr. Beard's interpretation would greatly sabotage the ethics code because the subject of an investigation could unilaterally terminate an ongoing ethics investigation, no matter how serious, simply by resigning. So if you knew that there was an adverse decision that was going to come your way, or you feared an adverse decision, all you have to do is resign, and the ethics board is rendered powerless to do anything about it. So, the problem with that is obviously as employees, if that's what the ethics code is interpreted to mean, they could violate the ethics code to their own advantage and enrichment, all the while knowing that they had the power to escape any repercussions for their actions simply by resigning.
So let me push back a little bit on that. And Ms. Cambray and I engaged on this notion that I could bleed the city's coffers dry as the CFO. And once I saw the ethics officer approaching, just give my notice of resignation, and as you say, I'm scot-free. Well, we know that's not true for Mr. Beard. He's been indicted federally. There are other remedies that could be pursued. The city could sue Mr. Beard. So why is it such a crazy public policy argument to say, hey, the Board of Ethics, which is not law enforcement, it's not the courts, it's a creature of administrative creation within the confines of the city of Atlanta. Why shouldn't its authority be limited to people who are still in the employ of the city?
Well, I think that would be an argument directed to the city council and the mayor who enacted this code. They clearly enacted this code so that the city would have some authority and say in investigating this matters and not leave it to a different body, a district attorney, a private lawsuit. Plus, we're assuming, for the sake of Mr. Beard's argument, I think, that every ethics violation carries a corresponding civil or criminal punishment or penalty. That's not always the case either. The list of possible actions that can be taken against employees includes such things like reprimands and administrative charges of up to $1,000. So this would invalidate all that as well. Just because there are alternative possible avenues to go after someone doesn't mean the ethics code is invalid as well.
I have a quick question about the very first provision you included in your ethics code excerpt.
Yes.
And that's 2-781, the official oath. That's just a copy of the oath. It's not one signed by Mr. Beard or Mayor Reed.
No, that was just on the same page as my 2801. It's 27-81.
Well, but it may be a happy coincidence for you.
Right.
Is that an oath that is your understanding Mr. Beard would have taken as an official of the city?
I believe so. I have no reason to think not.
Okay.
I don't have his signed oath before me to verify that for sure, but I would think so.
I'm just trying to understand, and I just bumped into that when I went to the start of the ethics code excerpt you shared. If the city is going to claim we can get you after you leave the employment of the city and maybe move out of the city and move out of the state, seems like you need to be on notice that there is a code of ethics that governs your behavior. And so I think I read this in the record, but you guys are going to need to keep me straight as to what was in I know I read it, so I assume it was from the record. Well, part of the record was showing that Mr. Beard had ethics training and had signed certain things so that, and I have not heard Ms. Cambray say this, but I think it's important to what I need to find. Mr. Beard, can't argue, I had no idea there was a code of ethics. I had no idea when I started here. And this would apply in particular to what you're arguing are examples of language that would be rendered toothless and meaningless if I gave the definitional section the meaning that Mr. Beard wants, the limitation on seeking business with the city for a year after you leave, the 2-810. For something like that to be enforceable, your employee needs to be put on notice. It's a non-compete kind of thing. And this isn't that, but it's non-solicitation, whatever you want to call it. For those to work, the person has to know that the provision is even there. So what is in the record that I could point to or that would make me comfortable that Mr. Beard at least was signing pieces of paper claiming he understood that there was a board of ethics and there were some basic rules that he needed to follow?
Well, I would have to cull through the record to provide that, Judge. I would think as the city's chief financial officer, it would be a tall order to argue that he didn't know he was governed by the provisions of the ethics code, especially as he is assumingly required to take the official oath as well. Now, whether that's in the record, I would have to call through it. It's 450 pages long, thereabout.
I'm gonna raise an objection here. I'm sorry to interrupt, but there is Mr. Endermark, all due respect to him, assumes that the city CFO would have done it. He can't point to anything in the record. He hasn't brought anything to the court's attention. It's in a record. With all due respect to Mr. Endermark's ability to assume, that is not evidence.
Well, I admit that. I admit it's not evidence.
Right. And so
I'm not taking it as evidence.
Okay.
And I want to be clear. That was one reason why I asked about, I thought that ethics code provision, whatever the number was, at the very top, 2-781 was put in there on purpose. I didn't know it was just, that was the end of the 7s, and then we get to the 8s. I thought it was put in there on purpose because part of Mr. Endermark's argument was going to be, look, Mr. Beard knew what was going on here, and for him to argue some surprise that there were these rules that might apply to him, which is not what you ever said, Mr. Grubman. I'm not saying that was the argument made below or now, but it is just something that I'm wanting to explore. And I thought I read somewhere, okay, it's here, it's in the record, in the final decision. This is where I saw it. Beard took ethics training, and so that's what was triggering in my head. Is I thought I read somewhere that he had been exposed to the world of ethics while working at the city. And on January 14th, 2016, it's paragraph 7 in the findings of fact, Mr. Beard had gone to an ethics training, and there are exhibits to support that. So I'm at a happy place now in that. Thank you.
All right, thank you, Judge. So if I think I left off that the problem with their interpretation is, as you point out yourself, Judge, it could render and I could say would absolutely render the ethics code completely ineffectual and toothless. And what it would do is essentially exempt anyone who does something severe enough that they'd be willing to quit over it from the ethics code. So what we'd be left with would be an ethics board or office of the Inspector General, as it's now termed, who could really, from a practical and very real standpoint, only investigate minor infractions that aren't worth quitting or firing someone over.
Or it would have to basically be a kind of star chamber where they do all the investigation with no input from the target of the investigation, reach their final conclusion, and then reveal it, because if the person quit, they'd be outside the jurisdiction of the...
And of course, they can't do that because the ethics code requires notice and all that, right, so that the employee can respond and provide information or attend the hearing and plead their own case.
Well, let's pivot to that. Let's pivot to the due process part.
All right. The first thing I want to say about that is I want to go back to this whole notion that Mr. Beard was asked to provide documents he didn't have or didn't have access to. I contend that that's not correct. If you look at, let me find it here. This is going to be Plaintiff's Exhibit 1. It's when he's notified that there is an investigation against him. It says he's allowed to file a response to the listed allegations. And then if you look at the second full paragraph, it said, please provide our office with the city business justification and all supporting documentation, and this is always left off in the pleadings, in your possession for all of the expenses listed below. They're not asking him to provide anything he doesn't already have. Now, his response to that was basically, I'm not going to provide anything. I'm not going to participate because you have no jurisdiction over me. And, that's a gamble, because if the board finds there is jurisdiction, obviously you've presented nothing for your side of the case.
Well, are you, again, Ms. Conray's going to have a chance to respond, but I'm wondering if you're simplifying a little bit. I think that's the main thrust of what the response was from Mr. Grubman, that you don't have jurisdiction over me, so no thanks. But I thought ultimately it was, and by the way, even though you don't have jurisdiction, we have no documents.
All right, let me address that two ways. Let's go specifically to Mr. Grubman's letter that said the computer's been repurposed. As Mr. Grubman rightfully pointed out when I was discussing the oath, simple assertions and argument of counsel are not evidence. And that's all we had. We had a letter from an attorney saying a computer had been repurposed that the ethics board had no knowledge of. There was no evidence of that put into the record before the ethics board, nor was any evidence put in that would state what these exculpatory documents were expected to be, when the computer was repurposed, what he wished he could have put in, nothing like that. It just said, we heard that a computer had been repurposed. And if you look at the findings, clearly the ethics board had nothing evidentiary to go on with that. Now, if he'd have come to the hearing and presented, sworn testimony or affidavits, maybe even regarding his, Open Records Act path, then maybe that's something the ethics board could have relied on. But to me, that's a red herring because that wasn't even evidence. That was simply an assertion of counsel with no supporting documentation and no evidence. So from that standpoint, I think that whole argument was never preserved below. As far as his assertion that he couldn't defend himself, that's really what his argument is. He had no ability to defend himself because of this computer. Even today, we have no idea what was supposed to be on that computer that he could have used to defend himself. Now, the ethics board offered Mr. Beard to come to a pretrial conference, pretrial hearing, where he could have examined all the evidence against him. There could have been some exchange of documents. He specifically declined to do that. So for him to now argue that he was somehow prevented from defending himself when he had every opportunity to prevent himself and declined at every turn seems to me not to be a persuasive argument from a due process standpoint. Due process means you're trying to participate, but you're not allowed to. He specifically refused to participate. And as far as, they're also saying that we tried to flip the burden of proof on him by making him prove his innocence. That's not the case. The ethics board compiled during a lengthy investigation hundreds of pages of documents and could find no business justification for any of it. So then the inference has to be, absent no other evidence, that shows that there was no business justification. If Mr. Beard had given a verbal accounting of himself saying, well, this is why I went here, this is why I went there, that might have been a different matter, but he specifically declined to provide any evidence whatsoever. So like any other case, if one side presents all their evidence and the other side abstains, you have to go on what the evidence presented is. There was no objection lodged to any of that evidence. There was no hearsay objections made. Obviously, we addressed that earlier.
Well, so when you say you addressed it, I addressed it. Are you agreeing that had there been a more adversarial proceeding before the board, then it might have been handled differently, but because there was no one objecting, it's really not for me to worry about whether the bulk of the evidence presented to the board was hearsay?
I would put it to you, Judge, that's not a matter properly before you because there was no hearsay objection made to any of it.
There's nothing for me to review, nothing preserved on that front.
Right. And as we know, under the new evidence code, you have to object to hearsay for it to be an admissible change from the way it used to be in the dinosaur age when I started out here.
Right. Rest just die.
Yeah. So they didn't preserve any of that. And it's not really listed in one of their enumerations of error on their petition either. And plus, even further from that, despite the fact that he ignored every opportunity to present evidence, ignored every opportunity, or I won't say ignored, that might be unfair to Mr. Grubman. I'll say declined every opportunity to present evidence and declined every opportunity to examine what the evidence against him was. His assertion that he somehow has no knowledge that he could have provided to the board because he didn't have access to his computers, for me, hard to believe. I mean, he took very expensive recent trips to Spain, to Paris, to China, and he's saying he can't remember why he went on those trips without access to his office computer. I find that hard to believe. But then again, the office computer thing, as I argued earlier, was simply an assertion of counsel that was never evidenced before the board. As I said before, access to city-owned documents is not always an issue. Their argument for a hard cutoff date of the second you resign, the ethics board can't do anything against you anymore. They're not arguing it can only not do anything against you if it's a long time after you left and you can't access documents. What they're saying is the second you quit your job, the ethics board is rendered powerless against you. And that would apply regardless of whether there were city-owned documents or not. So to interpret a statute or to overturn a statute based on this unique set of facts when it would apply to many different types of cases as well that these facts wouldn't apply to, I think is inappropriate. And yes, there may be, as was raised earlier, alternative avenues of seeking remedy against an employee who behaved unethically if it rises to a criminal matter or a civil matter. That doesn't mean that the ethics board can't also pursue statutorily enacted investigations and remedies. And you know, it's not much different than many cases. If you're a defendant who's alleged to have embezzled against a company, you can still be prosecuted months or years after the fact, even though you don't work there anymore. So to me, it makes it's a poor argument to say that the employee should have all the power to decide when an ethics investigation ends, and the ethics board should have no power to decide when an investigation should take place. All right, a couple other things here I wanted to address. Just first, as a matter of course, the official notice to Mr. Beard of the ethics complaint against him was on December 6th. Obviously, there were other things being looked into before that, and probably while he was still employed. But there's no dispute that the only things the ethics board is investigating him for are things that occurred while he was employed. I just want to make that absolutely clear on the record. They're not seeking any sanction for post-employment conduct.
Okay, I haven't heard Ms. Combre saying that. I mean, it's fairly well detailed in that opening letter of December 6th. There are 44 items that the board is asking Mr. Beard to provide justification for, and they all fall within dates that are within Mr. Beard's employment as CFO.
I just wanted to make sure I had said that at some point if I hadn't already.
Okay, you hadn't, but now you have.
Okay, thank you. Let me look at my notes here. So I addressed the issue that they never entered any evidence into the record of what documents would have been on the computer, or that those documents were now missing due to alleged erasure of the computer. That was not part of the evidence submitted. Indeed, today there's still no evidence of it. Today, what was on that computer or what documents would have been helpful to Mr. Beard, if any. Oh, the other thing I wanted to say is another provision that would be rendered meaningless by Mr. Beard's position is the whole section where you can seek a reimbursement of monies wrongfully taken from the city. If you're in receipt of unlawful or you unlawfully use city resources, as is alleged to have happened with Mr. Beard, and you're allowed by the code to seek retribution, which happened in this case, of some or all of those illicitly used resources. What good would that provision be if the person could terminate that whole process by quitting? Like you say, you'd have to have a star chamber where they didn't know this was going on until the opinion was handed down, which is not permitted under the ethics code. So I would argue, again, the very remedy in this case is further evidence of the intent of the statute, and that is to permit investigation into actions of people while they were employed by the city.
Okay.
As far as the request that the court remand this, obviously we would request that the court issue an order affirming the lower court or the lower tribunal's decision that Mr. Beard find that there is evidence to support the ethics board's decision. I really don't think that was ever raised before today, that there was no evidence to support the board's decision.
You disagree? I think you're right. I think Ms. Cambray tried to sort of shoehorn it into paragraph M of the grounds, but is she not correct in saying, well, if we're going to get technical about it, we'll just file an amended petition and add paragraph N as in Nancy that says, and by the way, there was not substantial evidence to support the board's decision?
Well, I would say that amending your petition on the day of the merits hearing is never a good thing to try and do. I would strongly object to trying to amend their petition at this stage. I feel handicapped. I never researched that issue, but I do know there's authority that says you're limited to the enumerations of error in the petition.
Okay. Well, I'm going to leave it right now. I still need to make sure there was substantial evidence, but that means any evidence. I'll work through that. If Ms. Cambray and Mr. Grubman decide they want to formally amend the petition, they'll need to, one, try to do that, and two, provide the law that suggests that they're entitled to do that. And if I were to permit it, which I would if they're entitled to do it, I would certainly, Mr. Endermark, give you a chance to respond, at least in writing. I don't know that we need to convene everyone again, but I will say this. I don't think the resolution of this matter rises or falls on the question of, was there any evidence to support the board's finding? I think it is much more about interpreting and implying that definitional provision 2-801, and then working through the due process concerns that Mr. Beard's lawyers have raised. So I don't think either side needs to get too worried about the evidence piece.
I would say, just in conclusion on that matter, Judge, I think, again, you can look to the underlying record. There was no allegation made that there was insubstantial evidence. There was no argument made to the ethics board on that. So really, for them to raise that at this stage is asking you to address a new argument that was not raised below, which is generally prohibited on appeal.
I guess
I know the whole writ of cert procedures are head scratchers.
Yeah, they sure are. But either way, I've said what I think about the substantial evidence. And I got that from Ms. Cambray. She didn't lead with that saying, the main reason why this is wrong is that there was no evidence. This is ridiculous. I mean, and some of that I think is underscored by the language of some of Mr. Grubman's letters, which are, look, Mr. Beard was really good for the city, so why are we having to do this? He brought in so much business. He was real busy. He was dealing with the Gulch situation. And that is one way to interpret that would be like, this really isn't a big deal. Not, there's no evidence. It's why are we quibbling over he went to a fancy restaurant? Because he was dealing with some pretty high rollers. The Gulch investment is measured in the B billions, not the M millions. So I think we've covered the evidence piece enough. Anything else you want to add, Mr. Indermark, or should I see if Ms. Combre has any rebuttal?
Let me just briefly check my notes to make sure I didn't miss anything. I think that concludes my argument, Judge.
All right, well, I appreciate your thoughts. Ms. Combre, I noticed you scribbling furiously during some of the things that were discussed. What do you want to share with me in closing?
Judge, might I just respond to the piece about due process and then turn it over to Ms. Cambry to finalize things?
You guys can break it up however you want.
Okay. I don't want to take away her thunder, and she'll have plenty, I know. But I wanted to discuss just a couple of things related to the due process. I won't say anything about the evidence piece because I think the court has highlighted their potential position, although I know you'll take it under consideration. Mr. Endermark talks about how if our reading of the statute holds, it renders the code of ethics meaningless. And that's simply not true, Judge. The purpose of the code of ethics is to set forth a code of ethics, is to set forth behavioral guidelines for employees. I mean, analogize this to a code of behavior for a private company. One of the absolute main purposes of any sort of code of ethics, code of behavior, is to tell employees what they can and can't do. So to say that, the fact that the city ethics board cannot investigate or at least impose sanctions, I mean, I guess they could investigate all they want. Really, right. The point is the sanctions part, that they cannot impose sanctions on a former employee. To say that guts the entire purpose, no, it sets forth a code of conduct. And on a similar but somewhat different note related to due process, what I hear Mr. Endermark saying on behalf of his client is, we said, we told Mr. Beard that we had concerns over certain transactions, and we offered him the opportunity to present an explanation. I'll give you an example. And Mr. Endermark, fairly, I mean, he pointed out a couple of large expenditures. And I'm not saying I agree with Mr. Endermark, but I understand his point of, oh, you're telling me that Mr. Beard doesn't remember why he spent, $15,000 and whatever. I understand that point. But then there's also other transactions, Judge. There's a transaction, just for example, since we're using example, for a restaurant or an expense at a hotel for $93 that occurred in January of 2017. So when the when the ethics complaint came out, it was December 2018. So nearly 2 years later, the city of Atlanta came forward and said, we have concerns about transactions. You need to explain them. And what essentially Mr. Beard said is, I can't, because when I work for the city, and I think I pointed this out in the letter, employees are required to save things on their city computer. It would be a violation for him to have saved, city documents, i.e. justifications for travel, on his personal computer, or to put it on a thumb drive. So he was saving these things on his work computer. It is undisputed that that hard drive was destroyed. And that was admitted in a response to an Open Records Act request. I would argue, Judge, and we could brief the issue if you really want to later, that the court could take judicial notice of information that's contained in a response to an Open Records Act request. But it is undisputed that hard drive was destroyed. They know it was destroyed. And now,
well,
Mr.
You say they, we need to make sure which,
Sure.
I mean, I don't know that we can attribute to the Board of Ethics the knowledge of the chief of police or the city attorney or this or that. They are different entities and they appropriately operate independently. So I think we've already agreed, at least I've found, that the communications you had, Mr. Grubman, with the city attorney's office concerning the Open Records Act, that was a stream of communication you happened to share with me as an exhibit, a proposed exhibit that was submitted for purposes of today's hearing. But I don't have any sense that, or evidence that that was something that the Board of Ethics knew about when they were considering the record before it. So
that's
how
fine.
does the Board of Ethics know that? I don't know that a hard drive was destroyed, and I don't really want you to dive deeper into that, because if it wasn't before the Board of Ethics, I don't want to be thinking about it. Usually, though, just point of information, when they're repurposing, they don't rip out the hard drive and put in a new one. That's expensive. They just wipe it, and that's destroying data, but not information. I don't know if they backed it up. I can tell you that in Fulton County, they back it up for situations like this. And so you might not be able to look at McBurney's old desktop to find information that McBurney saved on there, but that doesn't mean the information's gone. Now, I get it, the city was hacked and they've had some computer woes that the rest of us haven't, but just these examples, I think, are illustrative of why Mr. Indermark properly said, full stop. If it wasn't before the Board of Ethics, why are we gonna be running through the tunnels of data preservation, spoliation, et cetera?
Well, I would say, but it was before the Board of Ethics. I forgot the number. I think Ms. Cambry maybe filled in, but the Exhibit 14, which was before the Board of Ethics, they were on notice of these issues. But look, I don't want to go down a rabbit hole, Judge. I didn't mean to go down a rabbit hole, and I apologize if I am.
No. You're defending your client.
Right. But the fact of the matter is, to say you need to present us with justifications 2 years later, and you don't have, and if the response is, well, I can't because I don't have access to the information, here's why it's relevant to this hearing, Judge. Here's why it's relevant, because that proves the entire point of why the ethics code should be read to have a hard stop once someone leaves the city. For these reasons, because if you take away that limit, the only limit, I mean, Mr. Endermark, I appreciate, like me, I'm just making arguments for my client, so he's making the best arguments he can, so am I. But Mr. Endermark said, well, as a matter of practice, the ethics board only goes 2 years.
Right.
Of course, they could change their mind tomorrow, so that's no protection whatsoever. Right. I appreciate the creativity, but that's no protection whatsoever. So then legally, the only limit whatsoever is the hard stop when the employee leaves. And the reason we're focusing so much on the hard drive and all this is because these are the very issues that do arise when you allow the Board of Ethics to investigate forever. Theoretically, I'm obviously this is hyperbole, what I'm about to say, but it proves the point. There is absolutely nothing, Judge, under Mr. Endermark's reading of the Code of Ethics. Someone leaves the city in 2020, okay? And then in 2050, someone decides for some reason, 30 years later, to start investigating.
I hear you on that, but of two things. One, that's not this case. Two,
sure.
Just following on your example, there are a number of charges here as I look through that initial December 6, 2018 letter, where it would be entirely credible for Mr. Beard to say, you know what, I don't have anything to share with you on a restaurant in Atlanta a year and a half ago. I don't even remember that meal. And if the end result of all this was that the board said, well, you're in a lot of trouble because we destroyed your data by repurposing your computer, and you weren't able to justify the $500 you spent at the restaurant, I'm very underwhelmed by that, if that's what's before me. I don't think that the board would have handled that well. But to Mr. Endermark's point, as we go through this list, there are some memorables. There's flying premier business class to Frankfurt, Germany. You don't forget that, whether you're the CFO or not. He is not, some movie star who is just every day going all around the world. And he chose to provide nothing about why it was he spent $13,000 of city money, taxpayer money, to fly a real fancy class to go to Frankfurt. And he may not even have gone. He's buying tickets for other people. I mean, that's the other thing. Is we just explain why you're buying tickets for whoever Cheryl Chua is. And if you took the trip to Amsterdam, what was the business purpose for the trip? If his response had been, I don't remember any of that, then the board might react a different way. So we have a parade of horribles in either direction. And I've already brought up the one you did, which is, no statute of limitations. That certainly can't be that just because you're an administrative agency, you're outside the realm of due process, sort of like constitutional speedies with criminal cases. You can demand a speedy, and if you're not tried within a certain time, you're acquitted. But you don't have to demand a speedy to have a constitutionally speedy trial. And so if it were 2050, 5-0, and we were here talking about all these things, I don't think jurisdiction would even matter. It would just be, this is too little, too late. And the due process would be calling out for Mr. Beard to be free from this investigation. But the reality is it wasn't that far in time. And I'm not being asked to critique the code. That's not what, there's no declaratory judgment, declare the code to be invalid because there's not a statute of limitations. I don't think we get traction with that here for the larger charges. I think you make a great point for the smaller dollar amounts where all it says is, what's $90 at this hotel on this one day that was 2 years earlier. And clearly the gentleman traveled a lot. I'm not disputing that. But what he didn't do a lot was go to Frankfurt or buy ticket for someone else to go to Frankfurt. And that's the kind of thing where if we read the letter that was sent on December 6th, it says, hey, tell us what you remember about this. Don't tell us what we already have in city business records, but what do you have and what do you recall about this? And an approach that an attorney on his behalf could have taken would have been just what you do with discovery requests. I can tell you something about this. This one's too vague. You need to tell me more about the $7,500 given to the United Negro College Fund. I don't know how that's a city business expense, but it showed up on his credit card. So I think I got you on the statute of limitations piece, and it sort of applies perchance to a couple of the expenses, but there are some where it's not resonating.
Sure, I understand, Judge. And let me just say one more thing and turn it over to Ms. Cambry, because she was getting a lot more, yes nods from you than I am. So I'm just going to say one more thing.
You picked the hard one.
But the difference, Judge, with, you mentioned the hypothetical if we were in litigation. If we were in litigation, we thought that the tribunal before whom we were lacked jurisdiction. We would file a motion, it would be denied, we would appeal. Yes. And then a judge on the Court of Appeals would say, nope, there's jurisdiction. Then we would have the opportunity to go back and participate. We couldn't do that. We made the legal, it's a strategic decision. We made the legal strategic decision. We cannot, if we come in and say, hey, board, you don't have jurisdiction, but we do know the answer to that one charge, so we're going to go ahead and provide that response, then we'd probably be in front of you right now, and Mr. Endermark might rightfully be saying they waive jurisdiction, Judge. They participate in the process. So I think Ms. Cambry will probably conclude by saying if the court finds that there is jurisdiction, which we hope it doesn't, that there should be a remand so we can participate in the process. So now I will do what I think I should do, which is shut up and let Ms. Cambry take over.
Okay.
Thanks, Scott. I think I'll first address sort of the statutory issue.
I'm sorry, Ms. Cambry, I was muted for a second. I'm happy to let her have the final word, but since I'm sort of being tag team here a little, I would like to just take 20 seconds and address two things Mr. Grubman raised, if it would be helpful to the court.
So I have a question for you about waiver and participating, even though sort of a special appearance. but you can answer that after I hear from Ms. Cambry. That's the question I wanted. I just made a note that even though Ms. Cambry is going to have the final word, I'm going to want to hear from you, Mr. Indermark, on the concept. And I see it all the time, special appearance answers. We're answering because we don't want to be viewed as having defaulted or waived anything, but we do not admit or consent to jurisdiction in this court, subject matter, personal jurisdiction, whatever it is. That's a court, that's not an administrative tribunal, but I am going to want you to talk about that. So just hold your thoughts, and we're going to let Ms. Cambry go.
Yeah, so just want to, I think the first foundational issue in addressing the statutory interpretation question is, what does the code define official and employee as? And as you went through with Mr. Indermark, the last sentence in that definition would be unnecessary if it covered the conduct of all officials at any time. And the limitation on there is, or that if it covered current and former employees. And any reading of a statute that renders portions or language mere surplusage cannot be a proper interpretation of the statute. The principles of statutory construction that apply to statutes apply with equal force to codes of ordinances.
Well, I hear you on that, but then what's your response to Mr. Indermark's observation that 810 would be rendered meaningless? There's a whole provision, not just one sentence of one definition in a big section, but that entire section, 2-810, it would be surplusage. And certainly they didn't write a whole section just for fun.
No, they didn't, but that section specifically addresses or changes the definition, recognizes that the definition otherwise provided in the code is only for current employees, because they include modifying language such as no person who has served as or employee. You wouldn't need that language if it covered current employees. Furthermore, it goes on to say there's a modifier with such former official or employee who was directly concerned or in which official employee personally participated, etc. You wouldn't need the modifier former if the definition itself included former officials or employees. So yes, this one provision specifically applies to former employees and officials because it has language in there that makes it apply to former employees and officials. And that reading, you have to interpret that there's a reason why the city included that language in the statute. That was intentional. You would not need that language if the definition of employee or official contemplated the inclusion of former employees or officials. So I think that Mr. Indermark has pointed to a provision that supports our interpretation. And I think this argument about separating the act from the person renders the board's position fatal. The board does have authority to investigate any act that violates the remedial authority is limited to current employees or officials. That yes, you can investigate any action. You can investigate, things that involve third parties, contractors, vendors who aren't employees or officials of the city, or people who are transacting with current employees or officials of the city. So for example, if one employee was accepting bribes from a third party, you could investigate that bribe and potentially recover from that third party who was giving bribes to the official, but you could not, under the reading of section 807E, recoup the gratuities from that official, because it specifically says you can only recoup from officials or employees, which by definition excludes former. And the Pension Act somehow comes in. I have no idea where that comes in, either legislative history or otherwise in the code. And, all due respect to Mr. Indermark, his interpretation of the pension provision should have no bearing on the court's interpretation of this code provision, particularly when there's no citation to any legislative history that contemplates that that's the reason why the legislature, or the city, rather.
And it won't persuade me. That kind of question was like me asking you, well, do you know how other cities handle this? It was just point of information for me. I'm curious. This is a new area for me. So you will not see in whatever order I issue, well, it sounds like to me, the retirement board or the pension plan, it just was helpful to get some context.
I just wanted to make clear that there was no reason to interpret that based on the evidence that's
sure.
By the court.
I agree with you.
And, to address Mr. Endermark's point that our interpretation sort of renders the entire code of ordinances toothless is simply incorrect. There are other provisions, such as the provision of reprimanding, suspending, putting on probations, that don't apply to former employees anyways. It contemplates that you can't enact all of the remedial measures against everybody, because you wouldn't put somebody on probation who had resigned. And his assumption that everyone who was investigated by the ethics office would simply quit, and therefore the board has no ability to enforce the ethics provision, I just don't think is borne out by common sense. Not every ethics violation is particularly severe. If you're facing a $200 penalty, you may not be willing to give up your job, even if you are found guilty of an ethics violation. So it's not as if someone initiates an investigation and every employee subject of that investigation quits. Furthermore, people get investigated who are innocent. So people will defend themselves in these ethics investigations. And to say that just because you are alleged to have done something wrong, therefore means you quit and the board has no authority, I just don't think takes into account that innocent people are accused of wrongdoing all of the time and they defend themselves. And again, if it is severe enough, there are other remedies that the board or the city could undertake to prosecute egregious wrongdoing. There's no reason why the Board of Ethics has to be the safeguard against all embezzlement or fraud perpetrated by somebody in the city of Atlanta. So the code still has value. It still has meaning. Creating violations creates a deterrent effect, which achieves the purpose of the provision, even if there's no enforcement mechanism. Just saying something is prohibited will deter people from doing the prohibited conduct. So there's still meaning in the statute, even if the entire enforcement provisions were gone, which our interpretation doesn't do anyways. And I think that's all I had on the statutory thing, and just a couple of points on this due process argument. The first being this argument that the letter from Mr. Grubman about the repurposing of the hard drive was not evidence before the board. I candidly don't understand how that's not considered evidence. It's a statement by somebody.
I didn't hear Mr. Endermark, just so we're clear, I didn't hear Mr. Endermark say that the letter wasn't evidence. It's clearly something that the board considered. It's in their final decision. What I heard him say is that apart from Mr. Grubman's mere say-so, and I don't mean that pejoratively, but that it's Mr. Grubman saying this happened. There's nothing before the board. There was no IT employee from the city coming in saying, well, you know what? We do this as a matter of course. 3 months after separation, we take the hard drive, we wipe it clean, or we hit it with an axe and we put a new one in there. There was the mere say-so, the hearsay that you object to, and that would be the sole evidence before the board about a supposed repurposing of the hard drive. That's what I heard Mr. Endermark say. If you heard something different, keep going. But it wasn't that the board didn't know that there was an allegation about it. They did, and in fact, they referenced it.
Yeah, I think I just wanted to address that point where they seemed to be a little bit dismissive of that point just by saying, well, it's just an assertion of counsel. There's no evidence to, Mr. Endermark says that, we didn't provide any explanation of what those documents might show, why they might be exonerating, etc. And two potential arguments I have in response to that. The first being is that the statements of counsel have no less weight than the ethics officer's statement that transactions were made. That's potentially mere say so as well. Without corroborating evidence, there's nothing to say whether there was a business justification for these transactions or not. So on one hand, the board can't be dismissive of a statement of counsel and not consider the implications of those facts, while at the same time taking and giving great weight and inferences to the statements made by a hearing officer who also did not bring in somebody from the city to testify as to the veracity or provide further details to those documents. The second argument, and to address something specifically that Mr. Endermark said, is that we didn't explain what those documents might entail, but that's somewhat circular logic. You wanted us to explain what the documents would show when we didn't have access to those documents. And so it's sort of this vicious cycle and this expectation that Mr. Beard could be able to explain contents of documents to which he didn't have access. And I think it goes to our point that I think the board created some improper inferences and construed things in favor of the board, such as Mr. Grubman's letter, and things against Mr. Beard, such as he didn't provide any documents, and we're not really going to give a whole lot of weight to this repurposing argument. And I just think that there's some fundamental fairness issues there with how the board construed or made inferences based on the evidence, before it. And, Mr. Endermark said that plenty of opportunity was provided to Mr. Beard to provide responses to certain of these allegations, but I don't think that the board particularly appreciated that responding to one waives jurisdiction to the other. So we were, stuck in kind of a sticky wicket there, whether Mr. Beard probably does have responses to these and could comment substantively on them without needing documents. Documents would certainly support his position, but Mr. Beard shouldn't be required, straddle that fence while on one side trying to say, I object to jurisdiction, and potentially risk waiving merits arguments, or make merits arguments and risk waiving his jurisdictional arguments. So to sort of sum all this up, it is our position that the board doesn't have jurisdiction over Mr. Beard as a former city employee, and thus the decision of the board should be vacated in its entirety. But particularly this issue about gratuity should be vacated, because while the section about administrative sanctions doesn't incorporate the definition of official or employee, the subsection 807E does. So, there is a difference to be read there. So while administrative sanctions against a former employee might be appropriate, they are certainly not appropriate. The gratuities recoupment is certainly not appropriate for a former employee. But if you are inclined to find that the board has jurisdiction, then we would submit that in order to effectuate Mr. Beard's due process rights and mount any substantive defense to this case and lodge the objection that Mr. Endermark has said Mr. Beard failed to lodge by virtue of his non-participation, then we would respectfully request that the court remand the case and allow Mr. Beard the opportunity to substantively participate in the merits.
All right, thank you. Mr. Endermark, please share with me your thoughts about the concept or propriety, because this is not a court proceeding, it's quasi-judicial when you're in front of the board, of participating with reservation. In other words, I'm here, but I don't think I should be. I don't think you have jurisdiction over me, but I certainly want to be heard about the spoliation, my inability to recall some of the finer details of some of these rather picayune line items, and then my ability to recall details about the non-picayune, the $14,000 for this trip to this foreign country. Should that have happened more? I don't want should. Could that have happened? Or in this setting, you effectively waive by your actions?
That's a hard question to answer in one sense, Judge. In another sense, what Mr. Beard's attorneys are trying to do is sort of have it both ways at this stage. They're saying that what they told the
They're
board.
good attorneys. Why not? I mean, it's that's what I would do.
Like they're saying Mr. Grubman's letter to the board should have been considered, but at the same time, they weren't going to participate in any way. So I would say in one sense, they tried to walk a line. They're trying to argue both sides of it at this point.
But my question is, I didn't articulate it well. My question is this. Mr. Grubman is saying, in effect, a line we could not walk would be to show up and participate without functionally waiving our jurisdictional claim. And I know that in a court of law, that's not a correct statement.
No,
And
I
he didn't
don't.
say it in court. I'm just wondering if you have an argument to make, like, no, actually, Mr. Beard and lawyer could have engaged and just always, as a matter of reservation of rights, said, we're here, and this is going to sound annoying, but every time I open my mouth, I'm going to have to say, again, this body doesn't have jurisdiction over my client. But here's what you need to hear.
My position is that Mr. Beard could have participated, understanding his jurisdictional objection. If he preserved that objection, he could raise that on a writ of certiorari appeal to this court. And by participating in the hearing, if he properly preserved that objection, it would not be waived. That's my answer to that, Judge.
Okay. All right.
Judge, may I respond to just that one point, 30 seconds, 15 maybe?
Yeah, because I may ask you guys both to do a little research on that. So why don't you give me your verbal thoughts?
Sure, and that might be helpful for the research part for all of us, but the reason you can make special appearances in court is because there's case law that says you can, and there's rules that allow you to do so. There is no provision in the ethics code that allows you to make special, limited appearances for and maintain your jurisdictional arguments. And so while I appreciate Mr. Indermark's statement that he doesn't believe that would be waived, there's no law in that case. And he could have very well come up here and made the opposite argument had we participated in it. And that's the whole position is that's kind of proves the whole point, Judge. We were in a position where we had no guidance of whether a court would allow that. So the only way we could have known we were preserving our jurisdictional arguments is not to participate. Otherwise, we absolutely would have put ourselves at risk. We hope this is a moot point, Judge McBurney. We hope that you don't have to get to this area, but we are not aware of any rule that allows you to make special appearances before the ethics.
So here's what I'd like you to do. Well, I think we're concluded here. Ms. Lewis, was there anything you wanted to add other than it's been fun?
It has been a hoot, Your Honor, but nothing to add from me.
All right. Well, I appreciate you being here. I've heard lots of very helpful argument that breathes life into the contentions of the two sides. So this has been very useful to me. And I understand, Mr. Grubman and Ms. Cambry, your hope would be we don't even need to get to this question of, well, what about preserving an objection to jurisdiction? But insofar as the relief your client might get would be a remand, to me, the remand is fair and appropriate only if this was your only way to navigate the rock and hard place you found your client in, Mr. Grubman. I don't know the answer to that, and I'll look for it, but you're going to look for it as well. Hold on one sec. Sir, I'm back. We're having some HVAC issues, and the guy who can address that showed up, so I needed to get him to the right place. in chambers. The courtroom actually feels fine, but not so around it. So what I would like both sides to do, Mr. Indermark and then the team for Mr. Beard, is to poke around in the case law or statutes. I think it's going to be case law, to see if there is law that would be decisions that would be instructive in this area of wanting to maintain a no jurisdiction argument, but still participating in administrative proceedings. And that could be a state administrative proceeding. It could be a municipal one. It seems like this would have come up before in some setting, probably not with the Board of Ethics of the City of Atlanta, but across the state of Georgia. And it just would be helpful to see if there has been a Court of Appeals decision that says, actually, if you put your toe in the water, you're in the water, and you've submitted to the jurisdiction, and so you've waived the ability to say no jurisdiction. That would surprise me, but I get surprised all the time by the Court of Appeals, especially when they reverse me. There also may be nothing, which is what I'm hearing Mr. Grubman say, is that, hey, that there's it's something where we couldn't find guidance, and so we chose a particular course. And absent that guidance, Judge, the fair answer, if you conclude that the board did have jurisdiction, does have jurisdiction to investigate, and then to Ms. Cambry's finer point, to actually sanction by the way of trying to claw back the gratuities, former employees, then let us engage in front of the board, because we may have something to say. Part of which would be, we can't defend ourselves because you wiped the computer. And part of it might be, I do remember the trip to France, and here's why we did it. None of that happened. And Mr. Grubman's helped me understand why none of that happened. And that may have been a gamble that doesn't pay off, but it may be something that results in a remand. So I don't need anything formal. You're welcome to write a letter brief. You're welcome to send an email to Ms. Niles. We think these three cases, or this one case, might be helpful. And you're also free to write back saying, we struck out. Like Mr. Grubman said, there's nothing instructive out there. I don't suspect there'll be a case on point where it's X versus Board of Ethics that went to the Court of Appeals. But there ought to be something where someone is in front of an administrative agency, doesn't think he or she should be, and the Court of Appeals said, you certainly can preserve an objection to jurisdiction, engage, and then argue to us on appeal that regardless of the outcome, nothing should have happened because that administrative entity did not have jurisdiction. Does that question I'm asking make sense, Mr. Grubman?
Yes, absolutely, Judge.
Mr. Indermark?
Yes, Judge, thank you.
All right, Ms. Cambry?
Yes, Your Honor.
All right. And you guys let me know if, what is it, is Thursday, is getting something to Ms. Niles by next Wednesday too soon?
I think that'll be fine from Mr. Beard's perspective, Judge.
Okay, Mr. Indermark, does that jam you up, or does that give you enough? Again, I'm
trying to think, next Wednesday is not Thanksgiving, it's the week after, right? So that should be fine.
It's the week before, well, Thanksgiving is the week after, correct?
Right. So
next Wednesday is just another Wednesday.
That should be fine, Judge.
Okay. Let Ms. Niles know if you run into obstacles because of other things you're working on. But what I'll do is think about the other parts of the issues before me. And then Ms. Niles will share with me what you shared with her, and obviously copy the other side when you're sending something to Ms. Niles. And then I'll get together an order that addresses this petition for cert. Ms. Cambry, anything else on behalf of Mr. Beard?
Not today.
Mr. Grubman?
No, Judge.
All right, Mr. Indermark, anything else on behalf of the board?
Nothing further, Judge.
Thank you, everyone, for your work on this important matter, and I will give it the attention it